Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners interested in hearing some of the most thoughtful and forward-looking discussions in these fields. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Distribution and Franchising Committee of the Antitrust Law section. Today's episode asks, did the quick look test secretly switch teams? Every agreement concerning trade restrains. The true test of legality is whether the restraint imposed is such as merely regulates and perhaps thereby promotes competition, or whether it is such as may suppress or even destroy competition. So wrote Justice Brandeis in Chicago Board of Trade v. United States, explaining the rationale for the rule of reason analysis in evaluating horizontal restraints. To step back, agreements among competitors in the eyes of antitrust fall, for the most part, into one of two analytical buckets: per se illegal or rule of reason. Per se illegality applies to a class of restraints so obviously bad for competition and consumers that you don't even get a chance to wiggle your way out of it with wordsmithing or launching an iron rain of economists at it. These types of agreements include price fixing, bid reading, market allocation. And when an agreement is of the per se illegal variety, it's enough for plaintiffs to show the existence of the agreement. The harm is presumed. Rule of reason applies to the larger everything else bucket and is a more fact-rigorous and data-intensive balancing test of anti-competitive effects versus pro-competitive benefits. Under rule of reason, plaintiffs must demonstrate that the challenged restraint unreasonably harms competition by defining the relevant market, proving defendants' market power, and showing anti-competitive effects. The quick look analysis emerged as a third way to analyze horizontal agreements, falling between per se and rule of reason during a decades-long ideological shift of the courts away from the more liberal ethos which favored bright-line restrictions in antitrust to a more permissive approach towards business practices that lumped more of them into the rule of reason bucket. It was almost a way to inject a dose of common sense to speed up the litigation over a restraint that is pretty obviously bad, but doesn't fall into the traditional per se bucket, the observable in the twinkling of an eye standard, to borrow a phrase from Professor Arita. Quick look analysis starts with the presumption that a challenged restraint is anti-competitive and shifts the burden onto defendants to rebut by demonstrating pro-competitive benefits. Now, the Supreme Court has issued 4 antitrust opinions that explicitly refer to the quick look test: California Dental Association in 1999, Texaco v. Dagger in 2006, Actavis in 2013, and NCAA versus Alston in 2021. And although the court has made clear that a quick look inquiry can be substituted for full-blown rule of reason analysis, it has been maddeningly opaque as to when it can be used. Historically, quick look has been a plaintiff's tool, hence the phrase quick look approval, because it has relieved plaintiffs of having to demonstrate market power and define relevant product and geographic markets, which are necessary elements for a full-blown rule of reason analysis. Historically, quick look has been used as a plaintiff's tool, hence the phrase quick look approval, because it has relieved plaintiffs of having to demonstrate market power and define relevant product and geographic markets, which are necessary elements of a full-blown rule of reason analysis. But that may have all changed with a curious turn of phrase used by the Supreme Court in its 2021 Alston decision: quick look condemnation. Justice Gorsuch wrote that for restraints at opposite ends of the competitive spectrum, a quick look is sufficient for approval or condemnation. And he further said that quick look can also be used to evaluate restraints that, quote, may be so obviously incapable of harming competition that they require little scrutiny. So, has quick look, traditionally a sword for plaintiffs, now also been blessed as a cudgel for the defense bar? And how might this dicta impact cases going forward? To lead our discussion on this fascinating question is my co-host Travis Wheeler, shareholder in the law firm Maynard Nexsen, an adjunct professor of antitrust and trade regulation and law and economics at the University of South Carolina School of Law. Welcome back to the show, Travis.
Thank you, Anant.
Travis, who do we have for the show today?
Our first guest is Larissa Bergin. She is an antitrust partner in the Washington, D.C. office of Jones Day. She represents clients in an array of industries, including technology, financial services, retail services, healthcare, and pharmaceuticals. She represents clients in pharmaceutical and healthcare-related transactions and investigations involving prices, innovation, and market entry. And on the corporate side, she's overseen risk shift negotiations, HSR filings, second requests, investigational hearings, integration planning, and consent decrees with federal agencies. And her practice has involved matters before governments throughout Asia, the EU, and North America. She is a graduate of Boston University and the Catholic University of America, Columbus School of Law. And after graduation, she clerked for Judge Francis Allegra of the U.S. Court of Federal Claims. Uh, our second guest is, I'm not sure how many titles he has, Professor, Commissioner Chair Calvani, but he checks a lot of antitrust boxes, and we're not going to cover all of them. But after graduating from Cornell Law School, he worked in the San Francisco offices of Pillsbury, Madison, and Sutro, then spent a decade as a professor at Vanderbilt Law School before leaving to serve as a commissioner for the Federal Trade Commission. He then returned to private practice at Pillsbury in 1990, and during his second stint, taught antitrust at both Harvard and Duke Law Schools, where, in the interest of full disclosure, yours truly was his student, probably why I'm in this field. He finished his career at Freshfields in DC while teaching more antitrust at Cornell, Columbia, and UC Hastings Law Schools.
And Travis, just so our listeners are aware, 30 minutes before this episode recorded, a fire alarm went off in Larissa's building, which just tells you how hot of a topic this is.
Yes. And if she has to run out in the middle, there's probably a good reason. So just by way of background and in talking about quick look and standards to review, I'm going to use the phrase quick look to exculpate. And I did not coin that phrase. The second edition of the antitrust casebook that I started using in 2010 contemplated the existence of a quick look to exculpate and called it as such. And subsequent editions before Alston seemed to drop the reference and the notion of a quick look to exculpate altogether. And so this idea of an abbreviated rule of reason used by defendants to shut down a case was, for a long time, for me, a bit like Santa Claus to fourth graders. And some very much believe, some don't, and some aren't so sure. So we're going to kind of get into that today. Figured we could start off with Terry talking about your experience. You were at the commission for a lot of the formation period of the quick look rule, and maybe you could just talk through the development of that, as you recall it.
Okay, I'd be delighted to. But first, I want to thank the American Bar Association and also Travis, who's been my point of contact for the invitation to come join this distinguished group this afternoon. I'd like to take just a couple of minutes and explore with you the FTC's decision in the mid-1980s to employ what we called a structured rule of reason, which is also more generally probably known of as a quick look. There was the commission among a good number of people that believed that both the rule of reason and the per se rule had problems in some cases and didn't work very well. Sometimes the per se rule was over-inclusive and would punish entities for conduct that was benign or even pro-competitive. And at the underside of the spectrum, we had a lot of what I thought were inefficiencies built into the administration of the rule of reason itself. So what was the cap? And I guess the thing that we sort of remember in terms of over-inclusiveness was the Blaylock case. A female professional golfer named Blaylock was playing in a professional LPGA tournament. And an observer had seen her, at least in the observer's view, improperly improve the lie of her ball. This observer reported that back to the committee that was overseeing the tournament, and they wanted to confirm it. So they appointed a little committee to go observe what was going on. And I don't know whether they put on their fatigues and hid in the bushes or quite what they did, but they reported back that indeed they had seen the Miss Blaylock improperly move her ball. The LPGA convened a hearing and decided to bar Miss Blaylock from tournament play for a year. So, my goodness, what do? You're barred from play. First thing you do is obviously you go see a lawyer. If you get a really outstanding lawyer, they say, well, let's bring a private triple damage action. That's where you turn first. And that's what she did do. She brought a private triple damage action in the District of Georgia, if I recall correctly. Now, the really weren't contested. Plaintiffs put LPGA was a group that refused to play with her. That was a boycott. It was a group boycott, per se violation of the antitrust laws in the case. The defense lawyers wanted to talk to the judge about why this penalty was imposed. The plaintiffs objected, and the court said, I'm looking at the case law, it looks like it's a per se violation. So I can't consider the fact that this penalty was imposed by virtue of cheating. That gets into reasonableness. And so the court found in favor of Miss Blaylock. A lot of us thought that didn't make a whole lot of sense. On the other side, with the rule of reason, I always thought when I was a defense lawyer that even though we usually prevailed, that it was really an exercise in water torture. You had to go through and do market definition, and you had to analyze market power. Then you had to think about efficiencies. This brings in a whole battery of economists, and then consider other defenses. And Chicago Board of Trade case, it's a famous case for those of you that are maybe outside the states. It was authored by Justice Brandeis. Basically, everything is relevant in a rule of reason case, and nothing is dispositive. I used to teach a course. I said it was like the old Saturday Night Live thing, where everything goes into the basomatic and blended together. And so we had to actually think seriously about this when in 1985, the FTC brought a case against the Massachusetts Board of Optometry. The commission alleged, and this was not contested, that the board had prohibited all licensed optometrists from engaging in price discount advertising. Now, for those that don't live and breathe antitrust, the Supreme Court had a couple of years earlier decided that boards and commissions could not legally preclude price advertising, period, full stop, no defense. That was a violation of the law standing by itself. This case was a slightly bit different. It was the proscription of price advertising of discounts. Now, I personally had a little difficulty seeing the distinction, but anyway, people did. The case went to trial before the ALJ. The ALJ, I think it looked like, was leaning towards a per se offense or per se treatment, but then he ultimately decided it under the rule of reason. And he admitted that this case was slightly different from Bates, and that the Supreme Court had from time to time gave a lot of deference to professional regulatory boards. So he decided to consider the rule of reason in the case, but he found liability. The respondent.
Oh, and just to clarify for our listeners, ALJ refers to administrative law judge, which is sort of the administrative in-house proceeding that the FTC can do in addition to being able to bring these cases through regular Article 3 courts.
Thank you much for bringing that up. This lower-level trial judge, but under the rule of reason. The respondents appealed to the full commission, and I took the case for purposes of the opinion. My law clerks and I read the BMI case, where you had the Court of Appeals making a decision. This was really a group of competitors that were fixing prices, and the Supreme Court overruled that. And then in that BMI case, and then a couple of years later, in 1984, the NCAA case against Board of Regents. It was a case where essentially it was a horizontal agreement on the allocation of product. And there, the court actually employed uh, uh, rule of reason, but found liability without going through market definition, market power, efficiency, and all of the rest. So the commission then took what we put together, which was a paradigm that would go through is the restraint suspect something that almost always would be per se, and then if it was, we would ask, are there any efficiencies? And then are these efficiencies that are alleged to exist, do they really exist? And if they did, then it kicked over to the basic rule of reason. If they didn't, then the court could summarily find a violation. That prevailed for some period of time. During the Clinton administration, Chairman Potofsky didn't overrule mass board, but he didn't employ it either, because he believed that there were two rules per se, rule of reason. And so he went back to the conventional per se rule of reason. And then later in a case that the actual facts don't really matter, it was called the three tenors case, which involved sort of the same kind of facts that we had addressed except in a different industry, in mass board. And the commission once again employed mass board, going back to where we started. And the DC Circuit on appeal affirmed the decision of the commission and affirmed the use of either the what do we want to call it, the quick look or truncated rule of reason. So that's how all that got started, at least on the government side at the FTC.
All right. Well, thank you. And getting back to Alston and closer to the present, it's kind of noted already in Anant's intro, this was kind of the last in-depth analysis and application of the rule of reason by the Supreme Court. And in an extremely abbreviated summary, the plaintiffs were current and former athletes who sued the NCAA for limiting the amount of compensation that athletes could receive. It was a bench trial, and plaintiffs got an injunction related to the education-related benefits, but not as to the athletic scholarships and other benefits that were unrelated to education. Both sides appealed to the Ninth Circuit. Plaintiffs wanted an injunction to cover all compensation limits, and the NCAA was arguing that its education-related restrictions were reasonable. And so at the Supreme Court, the NCAA was arguing that it should not be subject to a full rule of reason. It wanted a more cursory review. The Supreme Court rejected this argument that no, you're going to get a full rule of reason, and then it sided against the NCAA unanimously. And it cited the language that Anant read earlier, which was Rothbury Storage Seventh Circuit opinion. And 2 years after that case, Professor Christopher Leslie published an article entitled "The Disapproval of Quick Look Approval: Antitrust After NCAA v. Alston" in the Washington University Law Review. Um, you know, and if you haven't read it, I would encourage anyone to read it. It's fascinating. But the article focused on this blurb from Alston about the quick look. And even though the Alston court didn't apply it in that case, Professor Leslie warns that this dicta, this perhaps innocuous sounding description of the quick look, may actually represent a substantial expansion of its reach. If I paraphrase too much, all of the blame, Professor Leslie, is on me. But as I interpret it, what he is saying is, up until Alston, the quick look was a tool for plaintiffs. It was a burden shifting tool for plaintiffs. It was always a quick look to condemn, and now it is Alston created this quick look to exonerate or a quick look to exculpate. And so really the reason we are here, now that, 4 years have gone by, and why in particular we have Larissa here, is to find out, less from an academic standpoint and more from a practical one, you know, how Alston, has impacted litigation and litigants. And, are defendants using this language to their advantage in antitrust cases? So, Larissa, from the sort of defense practitioner's perspective, have the floodgates opened?
Sure. No, thank you, Travis. I appreciate it and very happy to be here. So thanks for the opportunity. Thus far, it really hasn't opened the floodgates, which is not necessarily surprising. Just to kind of take a back step, and you kind of mentioned, right, that this was the first time that this version of Quick Look has been articulated. We have the Supreme Court who's stepping in, that's had a 10-day bench trial. They have a full record ahead of them. They've already determined that there's market power. They've already determined that there's been a horizontal agreement, right? And then they're trying to then assess, what amount of work is needed to determine what analysis should be applied. And they do mention that the vast majority of cases are addressed under the rule of reason. And, as Terry had mentioned, they're all the facts get to be put on the table, and they kind of get to pick and choose which ones they may want to apply. But that also has to do with the fact that they're afraid of potentially false positives, right? They don't want to condemn something unnecessarily. And so what they did say is that, despite the fact that there are all of these cases that are assigned under the rule of reason and analyzed under the rule of reason, there are some that are on the far reaches of the spectrum that could be addressed under this twinkling eye, right? And then there's the great in between that's going to, again, be under the rule of reason. And when contemplating whether or not it should be something that, again, that twinkle of the eye, that quick look analysis, they tried to say that, on the one hand, it may be a restraint so obvious that it's incapable of harming competition that it should be approved. And that's why we're here today, right? Is that is basically the quick look approval, that we're saying that it's so innocuous on its face that we don't need to do a deep dive. We don't need to perhaps go into all this fact investigation. Whereas on the other hand, and this kind of goes to the per se treatment, right, is that it's so obviously threatening to reduce output and to raise prices that it should in fact, be condemned. And so when you think about kind of that setup, right, we're now dealing with a Supreme Court that has said, yes, there is this possibility of a quick look approval, but they do say we should be using it sparingly, that it's very rare. And this kind of reminds me of perhaps the Trinco decision when they looked at Aspen skiing, which had to do with, refusal to deal. And they say Aspen skiing was on the outermost boundary. And I think that the court here is kind of setting up the fact that, yes, that there may be instances, in fact, where it really is quite easy to be dispositive case. But other than that, we really haven't seen it applied since the Alston decision has come through. So there are a few other reasons why I think you won't see the quick look approval come to bear very frequently. And that has to do with, again, some of the case precedent that's come since Alston. First, courts need to be able, to be familiar with the type of restraint that's undergone. Some cases, right, they say that there needs to be a rudimentary understanding of the economics that's going on with the restraint. And frankly, a lot of judges are not economists. So they're going to need help either from the defense bar or otherwise to educate them as to why that particular restraint may or may not be, an economic issue. Besides the looking at the type of restraint, you also need to look at whether or not you're familiar with the market. How are we going to define the market? How are the market shares going to be calculated? Markets change. Alston actually noted itself, right, that since the Board of Regents, which Terry was talking about, and now the Alston decision, a lot has been going on with the NCAA and the types of benefits that they've been providing students. So those are things that are considered as well. And then the last but not least, is the agreement itself going to be pro-competitive? And again, this is usually a fact-based analysis. And so absent there being a judge who has seen a case that addresses these issues, I think it's going to be very hard for him or her to ascertain that this should be quick look approved.
And at a minimum, I think maybe a quick look to exculpate, rare, probably not likely if the defendant has market power, as the court found the NCAA did in Alston. But just to try to see if I can get a little bit of daylight between you and Terry, let me just give a couple of scenarios and see, if these are perhaps, candidates for a quick look to exculpate. And I will start with the ASCAP, kind of BMI case, which a lot of people may be familiar with, but it was involved ASCAP and BMI both had sort of pooled license agreements for musical works. A composer could negotiate on their own. Probably didn't very often, but you could buy the ASCAP library with millions of titles, and you could buy the BMI. And the Supreme Court viewed these as separate, pro-competitive joint ventures, and the blanket licenses as sort of an altogether different product than the underlying works that made them up. Almost like four tires on a car. The car is one product, and it was not a express quick look case. The court said no, this is not per se, and it's rule of reason. But if we were looking at this, if this case came up anew today, and we were looking at either the ASCAP or the BMI blanket license, and not any sort of coordination between those two, might this sort of fit a scenario where we would say we don't need an 8-week trial to determine the reasonableness of the restraints created in the formation of these blanket licenses?
I mean, I wouldn't see a different result today than the result some years ago. I mean, you can look at it two ways. Since we're talking about the rule of reason, truncated rule of reason, and all of that, you can say that yes, this is a suspect conduct. It's price fixing suspect. Are there efficiencies? Well, the defendants argue there are. We looked at the efficiencies. Are they real? And yes, they are. And then you conclude that the efficiencies are not only real, but they're very important. Or, I think you could probably do it in a completely different way by saying, you guys are all fascinated with these various rules, but could somebody just say, it's okay if you do it because it's ancillary, but for the cooperation, this product would not be readily available. The only way that it's going to function efficiently is if they do this task, this combination, if you will. I think that to be true under the facts. And so I think you could look at it either way, the way that I would look at it. But somebody could say, well, you Americans are dummies just to create all these crazy rules that nobody understands. It's just a plain old ancillary restraint, which has been a common law idea for a very long time.
A couple of other hypos, and I do want to get to the Tucson dentists, but I also want to talk about snow shovels. And what I'm hoping is that, Terry, you will give this sort of hypo to Larissa and let her kind of react and respond. I know that you remember it because it was on my antitrust final exam, and I recall thinking it was fairly difficult. But I think it fits here.
Well, this was a hypothetical, supposedly, that Bill Baxter, when he was Assistant Attorney General, gave to senior staff at the Department of Justice. And he posed that there were some big box stores in D.C. that were hardware stores, and they were able to advertise their wares in the Washington Post by taking out a whole page saying, come stop by any of our locations. You can get this wonderful snow shovel during November at this price. And then there were some small hardware stores that couldn't afford a big ad in the Washington Post. And they decided to get together. There were three of them decided to get together, and they're going to jointly take out an advertisement in the Washington Post saying, you can stop by any of our convenient locations, separate names, separate locations, and buy this snow shovel for $9.99, if you will. And Baxter would ask, do you need to know any more before you decide whether to take the case or not? Attorneys all said, absolutely don't need to know anything was per se violation. We'll bring the case tomorrow. It sounds like it's an easy one. And Baxter said, well, what if these this three little people were able to make sales that they would not be able to make because nobody knew that they also had garden shovels that they're putting on for a very, very low price? Would that change your view? And they all said no. And then he opened it up more broadly and asked, well, what's really the right answer? Did I do was I fair in my recitation of something I forgot about 40 years ago?
For instance, these little snow shovel stores or hardware stores are trying to undercut the big box, and they can't otherwise afford to advertise the fact that they are pricing below them. It's to the extent that is output expanding, do we want to condemn that? And if not, is this sort of a another a place where this might be an appropriate use of this quick look tool?
Sure. No, great question. And I mean, obviously, there's some pro-competitive benefits here, right? Is that you're alerting other consumers that there's more availability. It is perhaps output generating. It may not necessarily be a naked restraint in and of itself. And, the advertisement may not have happened, but for the fact, right, that they all set the same price. Usually, though, when you have like a marketing tool, or as to say a joint venture or the like, usually there's some sort of geographic limitations, so that even though everyone's selling it at the same price, you have your own limited geography, and so you're not necessarily restricting competition amongst each other. So, depending on how far you want to walk when it's snowing, if you're in Boston and it's a foot of snow, perhaps it's a different geographical market than the others. But I think that, to your point, I think that, whether or not this would be quick look approval, I think would be a hard sell, just for the reasons that I've articulated. I think that this might be something that they might want to dig down and kind of understand more, whether this was something they were doing just for the purposes of the shovels, or if this was something they were doing long-term, things of that nature, to kind of generate why this isn't a naked restraint and this is ancillary to a larger purpose to, get out to the public and advertise their wares. So I guess, as they always say in antitrust, more facts need to be known.
And I think you confirmed that it was a pretty good exam question.
Well, it turns out I learned years later it's a real case. There was an investigation the Department of Justice launched in the District of Columbia involving liquor stores. And there were three independents that they could not advertise in the big liquor stores that had, a lot of shelves, a lot of booze. They were taking control of the market, really. They sold a lot. The little guys didn't sell much. The little guys got together and did the same thing with the prices, and same thing. Well, it goes to the Department of Justice, and the lawyers are keen to bring a case because it's price fixing, full stop. And the economist at the DOJ raised hell and said this is efficiency enhancing. You can't bring a case. You can't bring a case that's efficiency enhancing. And the division didn't know what to do, the front office. So they did to simply the file. They didn't. This case arose before BMI and before NCAA. So they didn't have some hooks to argue, frankly, very much, except that they didn't think it was the right thing to do. But they closed the case, and so it's just never brought, and there's no record, no nothing. The case just disappeared. Kind of interesting. Well, that's one way of getting rid of a case, isn't it?
And let me ask both of you if it is a fair reading of Alston, that maybe the court is moving a little bit away from the quick look altogether.
No, I think that may be true. I mean, cases even after Alston, have contemplated quick look several times, and in those cases, many of them in which they've decided not to go forward. In fact, in some no hire, no poach cases, when looking at it from a motion to dismiss perspective, had decided they looked at it from a quick look and allowed the case to move forward. But subsequent to that, after determining whether or not they could bring a class, decided that this was kind of out of their bailiwick, that there could be some pro-competitive justifications for those restraints, and reverted back to rule of reason. So I think, there have been courts that have tried to pressure test and apply quick look and have realized that absent the information they really need, they didn't think that they were really giving it the full weight that they should be.
Well, I want to be very careful not to tread too far into the Alston court's rule of reason analysis, because that will turn this into a mini series. But I could come back to Terry's Bassomatic Board of Trade, and whatever the Alston modern day rule of reason is definitely not that. It is definitely more structured, and maybe there is as the rule of reason has grown more structured, there is less need for these quick look off ramps.
I think the case is interesting for a couple of reasons. One, I think it puts paid to Christopher's argument that the case surreptitious weapon to enable defendants to win antitrust cases for two reasons. One, I don't think the court did that. I think the court, if anything, restricted the use of the rule of reason. You can read that case, particularly the paragraphs where they talk about at each end of the curve, there's a place for it over here and over here, almost saying in rarefied atmospheres. And the rest of the world would go back to binary rules. That's one of the ways that I read the case, and that's not consistent with this being a super weapon for defendants to avoid liability. Secondly, this case was decided by a unanimous United States Supreme Court in these days, a unanimous court on an antitrust public policy case. And that signals to me that there's not going to be any change in the court's reviews here, at least for some time. And you had let's face it, a pretty diverse group of people that came out in exactly with the same. I guess Kavanaugh did a concurring opinion, but the court came out with one voice, and it doesn't do that altogether that often in public policy cases. And so I just don't see this as a huge development that's a boon for the defense bar and a horrible day for the plaintiffs.
Final thoughts on that, Larissa?
I agree. I do. I agree. When you're trying to think about how the case could potentially fall under this quick approval, right? I mean, besides Rothery and Atlas van, right? I mean, we're talking about low market shares, low barriers to entry. It's a bunch of vans that are working together in a network to bring home goods interstate. I mean, we're not talking about necessarily like some of the technology markets we're talking about today, right? Or something else that may be a lot more difficult to define a relevant market and market shares and how and who else it's competing with. And so I just think it's going to be hard to find that ideal case. And I don't know who's going to be the first one who wants to kind of step to the plate for that.
Travis, this has been a great discussion. I know when we were talking about this episode, the one question we were trying to answer is, but in practice, would this work? We didn't want this just to be an academic discussion. I think we got some great context about the enforcement posture from Professor Calvani, and we also heard from actual defense attorney on the ground about whether this dicta changed the game. So, summarize for our listeners, what are your key takeaways here for practitioners?
So I think another way that we could read Alston is to de-emphasize the quick look. because it can go both ways, but only in exceptional cases at either end of the spectrum. Equivalent to exculpate is arguably appropriate only in exceptional, rare cases. I think that's evinced by, some of the hypos that I was sure Larissa would say, yeah, sure, we'd use that, and, maybe not. I think those would be, where there is clearly no harm to a market because of very low market share. If, we didn't get to the, Tucson dentist case, but if you're price fixing 2 out of 500 market participants with a market share in the 1-2% range, we don't think there can be any real harm. Or if a restraint is on its face output enhancing. If in the snow shovels example, in fact, consumers are able to, expand their choice of snow shovels, find more of them at a lower price, that might be a candidate as well. But, I think, it is not going, it is going to be very rare. And I think that is sort of borne out by, the what has transpired since Alston.
I want to thank Larissa Bergin, the Honorable Terry Calvani, and my co-host, Professor Travis Wheeler, for what's been an excellent discussion on the impact of the Alston decision on the quick look analysis. I also want to footnote prior scholarship of Christopher Leslie and Max Schulman, whose previously published papers I relied upon to bring myself up to speed on this topic. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.